on the application of Minott and Cambridge.
Yes, Mr. Van Heeden, sorry we've had a slightly late start.
My Lords and Lady, I appear for the appellant along with Ms Lovegrove, and my learned friend Mr Grundy and Ms England appear for the respondents. I'm going to divide our submissions into 4 parts, if I may. First, I want to set out 6 propositions, which I hope to make good during the course of my submissions. Secondly, I want to look at the law on the making of fresh homelessness applications. Thirdly, I want to look at the law on residence. And then finally, I'm going to make submissions in relation to the 2 grounds and mopping up whatever's left that I haven't dealt with along the way. So if I could start with our 6 propositions. I make these propositions on the assumption that the residence, which I refer to as residence in excess of 6 months and in the local authority area to which the application is made. And our first proposition is that residence is residence for the purposes of Part 7 of the Housing Act 96, whatever its quality. And it includes what the respondents have called the appellant's unlawful residence in this case. The second proposition is that the appellant's residence was a new fact, and that entitled him to make a fresh homelessness application.
Well, the appellant's residence exceeding 6 months,
yes,
was a new fact.
Yes. So
if he'd made his application after 3 months and another one after 4 months, would that still be a new fact?
Sorry, you mean he makes an application after 3 months? No, not new fact, because he hasn't got 6 months residence.
Yeah.
If he makes another one after 4 months, he's then got 7 months.
No, I mean, sorry, not 4 months later, but
Oh, right.
a month later he makes another one.
No, because he hasn't got 6 months.
So it's the consequence of the lapse of time that you say is important.
Yes. So
he's pushed over the 6 months.
yes. So I prefaced this by saying I'm referring to residence of 6 months in the local authority's area where he applies.
Yes, well, it's the change from not 6 months to 6 months.
Yes. Yeah. Yes, that's my proposition too. It's the change from not 6 months to 6 months is the new fact. And 6 months, obviously, in the area where he's applying.
Yeah.
Proposition 3 is that his residence gives rise to a local connection with that area. And I just want to
say it again.
The appellant's residence gives rise to a local connection with the respondent's area. And when I say his residence, I mean his residence in excess of 6 months in their area.
Does or might do.
Yeah. So
Well, which?
that's my primary submission is it gives him a local connection. But if I'm wrong about that, well, what I say primarily on that is I don't have to go that far. I don't have to show that his residence gives rise to a local connection. What I have to show, because this is about fresh applications, is that it's a new fact. And so what I hope to make good during the submissions is that whether or not he's going to go to a local connection is in fact a bit of a red herring. And
Well, that would be a decision for Cambridge to make
Yes.
if they were to entertain the application.
exactly.
And applying bets, it might or might not be good enough.
Exactly. But what they can't do is sort of entertain the application by saying you've got local connection, no local connection, then reason back and say because you don't have a local connection, you've got no new fact. Proposition 4 is that we would accept that some residence doesn't give rise to a local connection. I think that's my Lord's point. But on the facts of this case, we say nevertheless it's residence and a new fact. But one can envisage situations where unlawful residence may not give rise to a local connection, but in other situations it may give rise to a local connection. And similarly, lawful residence may give rise to a local connection, but in some other cases it may not give rise to a local connection. So that brings me to proposition number 5, which is that what constitutes residence and local connection really depends on the facts of each case. In my submission, residence and local connection, at least in this context, involve mixed questions of fact and law. So necessarily, in order to determine those issues, one has to investigate and inquire into the facts of each individual case. One can't have a general rule which is unlawful residence never gives rise to local connection, insofar as one can't have a general rule that lawful residence always gives rise to local connection. It depends on the facts. And that brings me to the 6th and last of our propositions, which is that on the facts of this case, there was residence, there was a new fact, and therefore the respondents had to accept the fresh homelessness application.
Is there any reason that you've deliberately not said normal residence in any of those propositions?
No, but
You've referred to residence throughout. Is there a difference?
I say no. I'm going to make submissions on that later, but I say
I
normal
see.
residence is where you reside, and it says that in the code, and it says that in Mohammed, I think. So it doesn't make a difference. Normal residence is residence. So yeah, proposition 6 is that he did have residence, it was a new fact, and therefore they had to accept his fresh homelessness application. They shouldn't have gone on to decide the issue of local connection. That was something that they could only do if they accepted the application, because that's a decision on the substantive merits of the application. And the test for fresh applications is not a merits-based test. It's not a sort of summary judgment. It's not a do you have an arguable application. It's a very sort of binary test. Is there a new fact or not?
Unless it's a trivial one, maybe.
Yes. Well, I accept, I'm going to go on and show this, but I accept that there are certain safeguards. So yeah, it can't be trivial or fanciful. So trivial in my submission would mean it's got to be relevant, which is why I preface this by saying it's got to be residents in their area. And obviously this is a local connection case. So if it's a priority need case, well, it might be a new fact, but it's trivial because it's not relevant to the issue of local connection.
Well, hang on. If it's got to be relevant, then then relevant means material. So aren't you back to the very test that Faya said didn't apply?
So I say it's not a materiality test, but I do accept that it's got to be not trivial or fanciful, whatever that means.
But I'm just puzzled by your glossing trivial as meaning not relevant. Relevant can only mean capable in principle of giving a different answer. And yet, I mean, you will gather I'm a bit puzzled by exactly what the Court of Appeal's gloss in Bagram amounts to. But
yeah, I don't claim
your
to have
body
the
language
answers
that
to that.
you may be too.
Yeah, exactly. That's what I said. I don't claim to have the answer to that.
Yes,
I think
okay.
that-
But you're stuck with it as a matter of authority. The
Yes.
trivial means something, whatever it means.
Yes.
Yeah, okay, well, there you are.
I think it means something different than relevant. As I say, I think relevant is, well, residence is relevant to local connection, but it's not relevant to other issues such as eligibility or priority need, whatever. Material, I think, does it make a difference to the outcome? So having established that the new fact is relevant because it's a local connection case, the residence is relevant. I think materiality is more of a merits-based consideration of, is it not only relevant, but is it such that it gives rise to a local connection.
Well, this is what always happens. If you start with 6 propositions, you find yourself being sucked into your submissions before you've got there. So let's park that until we look at those 2 cases.
So I want to move on then to the second part of my submissions, which is law on fresh applications. And if I could turn to the authorities bundle first, I want to start in the 96 Act at section 184. It's on page 20 of the authorities bundle. And in my submission, this is the starting point in respect of whenever an application is made. It's subsections 1 and 2. So subsection 1 places a duty to make inquiries on the authority where they've got reason to believe an applicant may be homeless or threatened with homelessness. And local connections dealt with in subsection 2, so they may also make inquiries whether he has a local connection with the district of another local housing authority in England, Wales or Scotland. So one proceeds from section 184, which is a duty when you get an application to take it, to make inquiries, and then at subsection 3, notify of a decision, 184 decision.
Is there any specified time table for the inquiries? Could they be completed, for example, in a day if there was a new application and the local authority decided, yes, we have a duty to investigate this, there is a new fact because the 6-month time limit is now, or guideline has now passed? Could they be conducted in a day?
Yes, I think I would extend that. There's no minimum, there's no you have to do inquiries for a certain period. Under the old code, it used to be 33 working days. And
even under the old code, that would be a maximum, wouldn't it?
Exactly. Yeah. So no minimum, but yeah, there used to be a maximum of 33 working days. Now there's something in the Welsh code, but in the English code there's nothing except there's paragraph 14.16, which seems to suggest that certainly in a priority need case, you generally should make your decision on the 57th day because the relief duty lasts for the first 56 days, and then on day 57 during the.
But I mean, I don't want to. That's all very interesting, and helpful, but we're talking about minimum, not maximum.
Yeah. So no minimum. So I accept you could turn it around, and a lot of authorities do turn it around in a day or two.
So on the basis that a local authority could make such a rapid determination, it could come, once it had accepted the new application, to a conclusion that the new fact is not material.
Yes, exactly.
Within the day.
Yes. So they could make a decision under 184 subsection 3 that he doesn't have a local connection within a day.
And they could have done that in this case if the merits so demanded.
That's what we say they should have done. And then, as my learned friend pointed out in his skeleton, under section 199 capital A, at that point, assuming that they refer to Samwell and Samwell accept the referral, their duties end at that point. And they say, you go to Samwell, and your application is treated as if it's made to Samwell.
And then you wouldn't be here if that's what they've done.
Well, then what we might do, depending on what the appellant says, is request a statutory review. And then if we don't like the decision on review, we appeal to the county court.
Yeah, and then you go to the county court, and just suppose that the county court said no under section 202. This is fine.
Yeah.
You could then make a new application.
Or if you had a new fact.
Yes, and could the new fact be the elapse of time that it had taken to get to the county court and the county court's decision? Or would it depend upon a consequence within that time frame?
If his fresh application was, I've been residing there for more than 6 months, well, that was the same new fact that he relied on to make the second.
What if he said, I've now been residing there for, let's assume the whole process would last a further 6 months, which it probably would with the county court, depending how quickly it could be passed through. Maybe an application to this court. He said, well, the new fact is I've been here another 6 months. I appreciate that the second 6 months doesn't have any special significance under the code, but it's a significant further length of time, and is capable of making a difference to the outcome. So that even if the authority could have said, well, that first 6 months, I know it's the milestone under the code, but in the special circumstances of this case, it's not enough. They'd have to reconsider whether, all right, 6 months might not be, but what about 12, which it would be by then? That is in reality how this could be done by a persistent applicant, isn't it? And there's no easy answer as long as they assert a fresh fact, which is not trivial, and a period effectively of any period of 6 months is unlikely to be trivial.
Well, so our case is, what made this a new fact was it wasn't 6 months and then it was 6 months.
I understand that, but I'm just trying, that happens to be your new fact in this particular case.
Yes.
But I'm just seeing how, if you are right,
Yeah.
it could play out in other situations.
Yes. But looking at the hypothetical, if he does another 6 months.
So would that be sufficient?
Yeah, I'm just thinking about
Oh,
it.
I see, sorry.
So if all the circumstances were the same, but it was simply lapse of time, so it was simply another 6 months.
Yes.
I think it might be said against him that it's just simply trivial. But if his status changed, so if he was suddenly then granted,
Things might have happened in that 6 months, then his new fact wouldn't be just the passage of time, it would be the things that happened during the passage of time.
exactly.
But your submission is, safe in the knowledge this isn't the facts of your case, mere passage of time might legitimately be said to be trivial. Although I think what we put against you is, well, if the test is ultimately normal residence, you're living in a place, it's hypothesized now for a year, how could it be said to be trivial?
I mean, it may be that there's no sort of right answer to that question, because, as I said, when one comes to look at the issue of local connection, one has to look at I say, what is relevant is the quality of residence. So it may be that it is a new fact, and maybe at that point, once he's done another 6 months, maybe that does give him a local connection, which he didn't have before. But I think there's probably no right or wrong answer to that. It all depends on its facts. As I said in one of my initial propositions, these questions are really fact dependent.
But on the basis that you're saying that the local authority cannot determine the quality of the, or forgive me, the merit of the new fact, you'd say that the elapse of a further 6 months would be a new fact that would have to be seized by the local authority, who would then have to would have the duty to make the inquiries.
Well, I don't think I go that far. It's not my case. I don't need to show one way or another, but I'm open to the idea that it might constitute a new fact, but it may not constitute a new fact. It probably depends on what's happening during those 6 months.
Yeah. Well, thank you. It's probably taken as far as we can to see how you put it. Coming back to your helpful trawls through the provisions, Section 1841. So we start with the duty to make inquiries. We've just been exploring the timetable.
Yeah.
Implicit in that. Yep.
And so, as my lady was suggesting, the procedure then is the statutory review, the appeal to the county court. And the appeal to the county court is section 204. I don't necessarily need to turn it up, but the whole purpose of enacting section 204 was to get these homelessness cases out of the High Court, get them into the county court, free up the admin court. And in my submission, that's part of the purpose behind the very low test of new fact for the purposes of making fresh homelessness applications.
Can I ask a slightly different question? You've shown us section 1842, which allows the local authority to inquire whether the applicant's got a local connection with another authority in England, Wales or Scotland. Section 198A1 allows a local authority to refer to another local authority in England. What happens if a local authority comes to the conclusion that the applicant has a local connection in Scotland, or for that matter, Wales?
There are some provisions about that, aren't there?
Well, I'm not sure that they cover this. There are provisions about reading authorities in England as authorities in Wales, but what happens if you've got a connection with Glasgow?
I don't know the answer to that question on my feet.
No, well, it just struck me as being curious. Anyway, it doesn't matter for the purposes of this case because Sandwell is in England.
Yeah. I'm just comparing it to subsection 1, which doesn't have the in England bit. I query whether you can refer the substantive duty, but you can't refer the relief duty outside England. But I don't know. I'd have to make some inquiries about that.
The provisions I had in mind, but my lord probably has looked at them properly and realises they are not actually on this point, was section 201 for Scotland, which is page 64 in the bundle. That may be a different point, and 201A, which is 65. That looks so it's
Yes, that may be the answer.
I don't know if I can assist. A difference emerged between the provisions in relation to England and in Wales and Scotland on the coming into force of the Localism Act and also the Homelessness Reduction Act. So that it used to be the case that all of the provisions in relation to local housing authorities and referrals were consistent across the constituent parts of the United Kingdom.
including Northern Ireland. Doesn't matter. Great Britain.
No.
Say Great Britain for the time being. Yeah.
But with the introduction of the Localism Act and powers of local authorities in England to effectively make offers that were outside of social housing provision in order to discharge duties.
I think we may be getting more detail than we want.
You are, but the provisions that matter to you really are the.
I understand, but my lord just asked a rather basic question, which we agree doesn't actually arise. Be interested to know the answer to. Is the answer that where a local authority in England wants to assert a local connection with Wales or Scotland, that is covered by sections 201 and 201A?
That is right, and it can't make a referral to a local authority outside of England before it's made a section 184 decision. Whereas because of the Homelessness Reduction Act, a local referral can be made to another authority in England before a section 184 decision.
There's a timing issue. Okay, well, we will have to be careful in our judgments to refer only to England and Wales.
I was going to...
England, sorry.
I was going to take you through that because...
well, okay, well, do if
in
you
due
have
course.
to, but not now. Thank you.
So the last thing I want to say before turning to the cases on fresh application is that the idea of new fact and that being a relatively easy test to satisfy.
You said the second bit. Yeah.
The purpose behind that is so that, generally speaking, the local authority has to take the application and make a 184 decision, and then that diverts the issue to the authority on statutory review and then into the county court, and doesn't, as it's happened in this case, mean that the issue ends up in the High Court. But I want to turn to Fahia first. I'm going to look at three cases: Fahia, Rika Begum, and then Ibrahim. So starting with Fahia, it's on page 142 of the bundle. And I want to start on page 147. So on page 147, at letter H, there's a heading, duty to inquire. And the issue that's then set out in that paragraph is that when one is confronted with a fresh application, a second application, is the local authority bound in all circumstances to go through the whole statutory inquiry procedure, or is there a threshold test? And then going over the page, one can see from the first paragraph that it was Harrow's case that the second application must demonstrate a change of circumstances, which might lead to the second application being successful. And it was for them to decide whether the test had been satisfied. So what Harrow were arguing is that it was a merits-based test, and they could look at the merits of the potential application, and if they decided that it wasn't going to be successful, they were entitled to reject it. And if one goes down to the next paragraph...
Well, it's not a merits test, it's a materiality test. Surely what they'd have to decide was whether it might lead to the second application being successful.
Yes. But that's a look at the merits.
It's a look at the merits, applying a sort of reverse summary judgment test.
Yes.
This cannot succeed, whatever our inquiries show, and therefore we needn't entertain it. And that's what was rejected.
Yes. And that's rejected in the next paragraph. And there's reference there to section 62, which is what's now section 184, which we've just seen. And at C to D, two examples of where one can reject a fresh application are given. So made by someone who lacks capacity. And then the next example is someone who's been given temporary accommodation. He's then found to be intentionally homeless, and he can't make a further application. He's then made homeless from the temporary accommodation. And then it's said at D, but those are very special cases when it's possible to say that there's no application before the local authority, and therefore the mandatory duty imposed by section 62 is not arisen. And then the last reference in this case is at F. So the court say that there's no shortcut available of non-statutory inquiries. And they suggest possible legislative amendment.
I mean, he does rather sort of... He uses different language at different parts in this passage, doesn't he? Just above E, he says, moreover, in my judgment, our application could not be treated as identical with the earlier application. That seems to be saying it wasn't on exactly the same facts. In other words, he's saying this isn't a Delahaye case. Is that right?
Yes.
So we got the concept of exactly the same facts just above D. We got the concept of identical, which seems to be the same, just above E. But then at the end, the paragraph, it's possible there's been no relevant change in circumstances at all. That is arguably a slightly different formulation.
It may become slightly clearer when we go to Rika Begum, because Fahia isn't the law, but it's what led to the conclusions in Rika Begum. But I take my lord's point. There are various different descriptions of what the test is.
The reasoning seems to be, if there is an application, the housing authority has a statutory duty to inquire. Therefore, you have to, the only way to get out of that is to say there is no application at all. What does that mean? It means that it's the same, i.e. the identical application to the one that was made before.
Yes, and I think it's that reasoning which finds its way into Rika-Begum. And I refer to this case for that proposition, but also because in my submission, this idea that one somehow looks at, if it's not merits, then the arguability of the fresh application or the prospects of success of the fresh application is rejected as a concept. And one can quite understand why, because that's going to involve difficult questions. Whereas are there new facts or not should be relatively...
Well, you may well be right. I think you are right, but let's look at it. Begum prompts, basically goes for the doesn't fasten on the no relevant change in circumstances, what language, for reasons which Lord Justice Newberger explains.
Well, let's look at Begum now. I think we've dealt with Fahia. So it's on page 159. And in my submission, the relevant passages start on page 170, paragraph 38. And I agree with my lord. And I think what happens in Rika-Begum is they reject any idea that there's some kind of materiality test.
Is it helpful to look at paragraph 27 following, where he goes through the previous cases?
Well, I jumped to 38 because I thought he sort of summarised.
Maybe you're right. I just wanted to see what, because Delahaye we haven't got in the bundle, and the law reports always pretends it was only reporting the Times. There probably was a transcript available, but
You can get a transcript on Lexis, as it happens.
that sounds like my lord not only knows you can, but has, which I'm afraid I haven't done. It's only first instance, so it doesn't perhaps help. Yeah, well, there we are. So, yes, but anyway, he looked at Delahaye at para 28. McCulloch at 29, as Chambers 29.
Yeah.
As you say, Pat, I just wanted to remind myself of particularly what had been said about Delahaye. You're obviously right that he attempts to reconcile those authorities and does it authoritatively as far as we're concerned from para 38 onwards. So, fine.
So 38, the conclusion is that those cases which he looked at previously, Chambers, McBain, Campisi, Delahaye, they're very difficult to reconcile with Fahia. And at the end of 38, there's the quote from Campisi about material change of circumstances since the original decision. And then at 39 in my submission is what's decided in Rika-Begum.
So that picks up the application has to be shown to be no application.
Yes.
And the only relevant basis on which it can be treated as no application is where it's based on exactly the same facts.
Yes. And then he says that isn't the same as no material change of circumstances.
Exactly. So he rejects the materiality approach in favour of a rather sort of binary approach. Are there new facts or not? And then they look at the difference between the two tests. And at paragraph 41, Mr. Luber contended the requirement of exactly the same facts in Fahia is a more precise test, which is harder to satisfy than that of a material change in circumstances. I think what he's saying is it's harder for the authority to reject an application on the basis of that. And then he refers to the very special cases, contrast with what was said previously about fresh applications, which is they can be rejected in the majority of such cases. So for an applicant, it's a very much easier text. And it doesn't necessitate looking at merits or materiality. Query the extent to which it involves looking at relevance.
Can a renewed application ever be said to be on exactly the same facts? I'm sorry, it's a broken record again. If there has been a further elapse of time.
I mean, context is everything. So if it's a priority, if it's anything other than local connection, then it's not. My submission would be it's not a new fact. Because I don't see how a lapse of time could be relevant to a priority need case.
Well, what about somebody who turns 16?
Exactly. So it depends what happens in that time. I was going to cite the example of someone who had a terrible accident and was then confined to a wheelchair. I mean, that must.
But lapse of time would make somebody 16 who wasn't before, and then they automatically fall into a priority need class.
It may not be helpful to regard those as really lapse of time cases because they are simply events which have happened in the elapsed time.
Yes.
Whereas lapse of time, as I understand it, picks up the notion that the longer you live there, live in a place, the easier it is to say that you're normally resident. It is true that in certain unusual circumstances, I think in principle you can say you're normally resident somewhere from day one. But in many cases, the duration of the residence is relevant to whether it is normal. And on this ordinary basis, the longer you're there, the easier it is to say that it's normal. And I think mere lapse of time is really addressed to that argument.
Well, our case doesn't really rest on mere lapse of time because it's what's happening in that time. So in our case, we say residence which gets over 6 months.
Yes, but the 6 months, you say that, but the 6 month, it's not a statutory thing.
No.
It is simply a working definition, to use the language of the code, of the very phenomenon that I've just been discussing.
Yes.
I.e., if you've been there 6 months, you have been there long enough for it to be regarded as normal.
Yes. But what one's looking at is not merely the lapse of time, but what's happening in that time. So it's residence within that time, or it's...
Oh, well, of course it's residence within that time. Yeah. I mean, it's a composite phrase, normally resident. But
yeah. Or it's you turn 18 in that time, or you had...
No, I think all your other examples are different from your first. Residence in that time is relevant. Just mere passage of time is relevant to whether it's you're normally resident. Whereas things that happen in that time are of a different, that's really a different kind of point, that you've turned 16 or that you've had an accident or that, I'm always very unimaginative about these examples, but other things that happen in that time. That's not really a passage of time point at all.
But
the new fact then is that you have become 16.
But if you weren't resident, then the passage of time would be...
But just suppose...
It's passage of time as resident.
Yes.
I mean, you saying normal resident and resident are the same thing. I'm not persuaded by that.
I'll come to that. A lady.
But rather just, if we had a situation whereby someone could say, and this presumes on your basis that the 6 month time indicator is being passed, this is a new fact because I have been living in the same house for an additional 6 months. Not, as my lords have said, because I've got a child who's now turned 16 or whatever, but I have just been living here longer. And I'm just wondering if there's ever a basis to say that it's not a new fact.
Well, I'm open to that. I don't think one can lay down hard and fast rules and say...
But if that's right, there will never be an application that's not a new fact situation, because time has gone by.
Well, I'm not sure I agree with that, because I don't think it's always a new fact, and equally, I don't think it's never not a new fact. I think it all just depends on the circumstances.
Well, very broadly speaking, it must depend on how long.
Yes, and the quality of that residence.
Quite sure what that means, but yes, possibly, yeah.
It seems to me that the longer you're there, the more likely it is to be a new fact. It may be that if you're there lawfully, it carries more weight vis-a-vis local connection than if you're not there lawfully. I wouldn't say there's a hard and fast rule as to whether or not.
It's just very difficult to know what exactly the same circumstances therefore mean.
Well, on the face of it, it's a very low threshold test, isn't it? Because it would seem that any change amounts to a new fact. One can imagine a whole host of hypotheticals as to whether it is a new fact or not. I mean, for the purposes of this case, in my submission, as I said at the start, we do have a new fact because we were there and we were there for over 6 months. And that.
But the ultimate question is, can you say that this purported application is no application at all?
Yeah. You can only say that if it's identical to the previous one.
And do you happen to know of any authorities where the court, as it were, has not been, the decision of the court has not been challenged on the basis that there is no new fact? All of the authorities, as I think has been determined, raise the issue of where there has been an application disregarded that should not have been. Is there any authority the other way, where the decision has been upheld that this really is a no new fact case?
I don't know off the top of my head, and my lady's right, all the cases in the bundle and the cases relied on by both sides are all cases where the court has decided there are in fact new facts and the application should have been taken.
That chimes with Lord Justice Newberger's point at the end of 53, page 174, will be a relatively rare case where the facts of the two applications will be exactly the same.
Before we get, yes, and that chimes with the what we saw in Fahia, which I think is
yes, that comes from Fahia, in fact. Yeah.
Before we get there, can we just look at paragraph 46 on page 172, which is the procedure. So you have to compare the facts as they were at the time when the early application was disposed of with the facts revealed in the document by which the subsequent application is made.
Now that's not quite accurate, is it, in the light of what Lord Justice Newberger says later? The facts as they were at the time when the earlier application was disposed of are the facts as found by the local authority. What is revealed by the document in the subsequent application may or may not be facts. They are, at that stage, allegations or assertions.
Yeah. Well, that's illustrated.
And I think that's why, when he talks about things being fanciful, it's tied back to what is said in the application.
Yes.
So you are in 46, you are comparing on one side of the balance facts as found, and on the other side of the balance what the applicant asserts.
Yes. Yes. I'm going over the page to paragraph 49 and 50. The court is here setting out sort of reasons for the approach. So they say in 49 that approach sits with section 184. And then at 50, there's no room to imply a further requirement of establishing a material change of circumstances. Any such implication faces insuperable difficulties in light of the decision in Fahia. A person seeking to imply words into a statute faces a difficult task. It is a course which can only be justified in clear and unusual circumstances. where the implication involves imposing a further requirement over and above express requirements imposed by the legislature, the task is, in my view, particularly difficult. I say that applies not only when one looks at 184, but also when one looks at section 199 on what's residence. You can't start implying other words into the statute. And then at 52, just making the point, which I've already alluded to, about the statutory review process in 202, the appeal to the county court in 204. Of course, there's the engagement at the end of 51. There's the engagement of interim duties to accommodate. So all of that is circumvented if an authority is entitled to refuse the fresh application. So a potentially meritorious applicant wouldn't be able to enjoy the...
Well, no, he wouldn't be potentially meritorious, because by definition the decision would be made that the application had not materially different from the previous, it's hypothesized, correctly rejected application.
Yeah. But I say potentially, because if the authority is wrong about that, as
then
they
you
were,
have to judicially review them.
Yeah.
Yeah.
And as we've seen in this bundle, those judicial reviews were all successful. So there one had successful appellants, but they didn't get the benefit of the interim accommodation duties, insofar as they existed,
I see that.
or the internal review, or the 204 appeal. And then one can see at 53 that all those problems are avoided if one takes the low.
Here he uses the phrase precisely the same facts.
I take my Lord's point that various descriptions of the test. And what's said over the page 174, between A and B, is the only inquiry is a comparison between the subsequent reported application with the already established facts applicable at the time the earlier application was disposed of. Simple inquiry. As my lady said, that could be done very quickly, possibly within a day. And then the relatively rare case. And then the procedures set out at paragraphs 59 to 61.
Can I just ask you about that? If we go back to 54, Lord Justice Neuberger turns to the consequences of this analysis.
Yes.
And he says at E, the second application was a valid application and should have been accepted and treated as such by the council. My reading, correct me if this is wrong, is that that is the ratio of the case, and what follows is all obiter. Because by the end of 54, he has decided the appeal.
Yes, and I think there's support for that in 58, because he prefaces what he says in 59 to 61 by saying it may be helpful to give some guidance. So he's not saying that 59 to 61 is necessarily ratio, he's just saying this is some guidance which I think you may find useful. And then the three-step process that he sets out at 59 to 61, very briefly at 59, so the applicant has to identify the new fact. And then here he's using exactly the same test. And if it's not exactly the same, you can reject it. Secondly is the carve-out. So if it's not new, fanciful or trivial, And then he says it's not appropriate to expand on what may constitute or are fanciful or trivial alleged new facts, because that inevitably turn on the particular circumstances of the particular case. I think we've already seen that problem.
I suggest it's important to realise that what he's talking about are alleged new facts. If a fact is found, it seems to me to be difficult to say it's fanciful. It might be trivial, but it's difficult to see how it could be fanciful.
Yes. I agree with that. They must be alleged facts, because at that point the authority hasn't carried out an inquiry into those facts and cannot carry out any sort of substantive inquiry into those facts. So they are simply alleged facts, and it may turn out on inquiry that those facts aren't in fact facts. That's why it's such an easy test, because the applicant puts forward the new facts, which largely the authority has to swallow, unless it's pretty obvious on the face of them that they're fanciful.
Can you give an example of such a case?
Well, the applicant may say, I had a terrible road traffic accident, I'm now in a wheelchair, so I'm now in priority needs, and then he rocks up to the homeless persons unit and his jogging stuff, and they say, well, actually, what you said in your application is a load of rubbish. So
Then they've made a determination of the fact that he asserts subsequent to the application.
oh, no, I'm hypothesising a situation where he turns up to the homeless persons unit to make his
To deliver his application.
Yeah. But yeah, of course, if they've then accepted it, So
My home has been destroyed in an earthquake.
And then it turns out it hasn't.
Well, I think that's slightly fudging it, said that it turns out it hasn't been. It's fanciful because everyone knows there are no earthquakes in Cambridge.
Well,
Always been. Was struck by alien space visitation. That's seriously fanciful, but
I mean, I can't, and Lord Newberger doesn't give a definition of what's fanciful or trivial. He rather says it all depends on the facts of the case.
well, fanciful. I think we've got no difficulty understanding it. Trivial, I've already explored with you. I'm not sure we can take it much further.
Yeah.
I'm puzzled by what trivial means if it doesn't mean not capable of being material.
So I think fanciful is a credibility issue. Is your fact obviously not a fact?
Yep.
Trivial, I agree. I mean, I have difficulty with that. I think it's some sort of relevancy threshold, which doesn't quite stray into merits. Or
I don't quite know what relevancy means. Which if it isn't
No, I made my last
materiality.
application on a Tuesday and I'm making this one on a Thursday.
Yes. Obviously trivial. Doesn't matter. So that's Rika Begum, and then the last case on fresh applications that I want to turn up is Ibrahim, because I think it's the most recent one we've got.
Is that Mr. Justice Tool?
Yes, page 391. The ratio of that case is that a new fact can be something that pre-existed the determination of the previous application, but it just wasn't accepted as a fact by the authority. And the only reason I want to turn this up is for page 409, paragraph 104.
So sorry, which page are we on?
409, paragraph 104.
Thank you.
So this was a perversity challenge, but 104 at 104. he proceeded on the basis it's necessary to establish conventional grounds for judicial review. So he's not saying these challenges are confined to perversity, the general public law remit. But it's important to understand what our case is. Our case primarily is not that you necessarily got it wrong that he doesn't have a local connection, but it's a process argument. You couldn't make a decision on the substantive merits of his case and whether or not he had a local connection and use that as the reason why he didn't have new facts to reject his fresh application.
Well, you say essentially stage one is this a new application? If the answer is yes, then the duty to make inquiries is triggered. Stage two, has the applicant got a local connection? Answer maybe yes or maybe no, but that's part of the inquiry process. And effectively you say, well, Cambridge wrapped up the two parts of the process together, and they shouldn't have done.
Yes. And the very fact that they did that showed that they should have accepted the application, because it was something that they needed to inquire into, and they needed to ask themselves various questions of fact and law, which goes way beyond what they should have done when they were presented with a fresh application. I want to just divert here to the core bundle to look at what they did decide. What one's comparing is the facts at the time of the previous review, which was 25th of September 2019, where they decided he didn't have a local connection because he hadn't been there 6 months, and the facts as at the date of the new application on the 17th of October 2019. And his new application's on page 156, but I don't intend to take my lords to it. It's accepted and it's obvious that what he was saying his new fact was 6 months residence. And it's dealt with in two emails.
Sorry, well, page 156.
Yes.
My bundle stops at page 154. Were we sent to no?
I've got it.
We were obviously sent the decision, or either that or it's fallen out of my bundle, which is not impossible.
I think it
I was puzzled that we hadn't got the original decision, but I thought it was sufficiently summarised in the judges.
We don't have the original decision. This 156 is the second application.
Yeah.
Oh, I see. Sorry, but
We don't have the original.
GT Stewart.
actually,
But we do have it for my lords and my lady if you want to see it.
no. That's a separate question. Sorry, I wasn't sure what you were taking us to. You are taking us to something which is at page 156. Can I have a copy? I'll borrow my lord's.
It's the letter from GT solicitors making the second application.
Right.
Your notebook.
It's the second page, page 157.
There you go. My learned juniors can hand hers up, my lord.
That's very helpful. It doesn't really matter, but I'm always puzzled. Was the bundle added to at some point and it just hasn't got through to me, or have I been uniquely...
I don't want to say you've been picked on, because I don't think it was.
Yes, there's a fresh index. No, there's a fresh index. These are items 13A and 13B in the index. Oh, and there's some stuff at the end. Yeah, I'll tell you what. I'll give your junior back her bundle. I will just take out the final pages, if that's all right. I'm sure she knows it's all backwards. It doesn't matter. There's something going wrong. it often happens. I'm not certain it's anyone's fault.
So yeah, the comparison is with the previous review decision, which isn't in the bundle, but we do have copies and we can hand it up if my lords and lady want to see it. I'm in your
For
hand.
completeness, it'd be,
I think
be sensible to have it.
that's what the comparison has got to be.
Absolutely typical, isn't it?
So the comparison is with that document, which is the review decision, and the document on page 156.
Thank you.
I don't intend to look at those in any detail. What I do want to look at is the respondent's response.
Thank you.
As I say, they produced 2 emails in response. The first email is on page 149, and the second is on page 152. I just want to spend a little bit of time looking at what they decided. So the first email on page 149, sent on the 21st of October. First paragraph says that they can't agree there's a change of circumstances. And then paragraph 2 in my submission really contains the reasoning. No reason that a new application needs to be taken. Firstly, they set out the taste and fire here. Your submission does not provide new information. The reason for this is because Mr. Minott does not have a local connection to Cambridge. But that's the local connection decision, and that's the reason why they say there's no new fact. And then they set out why. So they set out what the reasons for their local connection decision. Firstly, he was there without permission for long periods of time. And secondly, he was there after Sandwell accepted the referral. And then at the end of that paragraph, it says, at both dates, he does not have a local connection and has not gained 6 months within the borough in temporary accommodation pending inquiries. And then they say, so to summarise, Mr. Minott does not have a local connection on the grounds of normal residence. And then their second email is on page 152, 29th of October. It's in response to a further letter from the solicitors of the 23rd of October, which is on page 2 of the supplementary bundle. But again, I'm not going to take my lord to my lady to do that. So on the 29th
Sorry, page 2,
of the supplemental bundle,
that's Mr. Minott's witness statement.
so the respondent put
This
in
is
a,
this one, is it?
yeah, the respondent put in a supplementary bundle.
Letter before claim.
Exactly.
Right.
So they write their letter before claim, and that triggers.
So I'm really sorry to interject. If my learned friend is going to take you to the council's responses to applications, it seems to me unbelievable that you're not being taken to the content of those applications.
I'm not
Surely
sure it's
that-
unbelievable at all, Mr. If you want to take them to us later, you can.
I will, but it seems to me to take it out of context, because we could at this stage go through all of the factual material, or Mr. Toby Van
You'll have an
Hayden-
opportunity to do that later, Mr.
Thank you, Mark.
So on page 152, this is the second email, 29th of October. Please find below the response to your points below. 1. It's our assertion Mr. Minott does not have a local connection. So consequently, there's no change of circumstances.
Yeah.
And then point 2. The issue is whether a local connection has been gained through residence.
Yeah, this is all just making good your point that although they're saying there's no new fact, the reason they're giving that there's no new fact is that the new fact asserted doesn't. Is that there is no local connection.
Yes.
Which is not a relevant question at the new fact stage.
Exactly.
Yeah, we've got that point.
And the other point I want to make is effectively what you're presented with here is a 184 decision that you don't have a local connection.
Yeah.
And that 184 decision has been based on a number of inquiries, which in my submission are impermissible at the fresh application stage.
Well, that's really just icing on the cake, because there was another aspect of the basic point that this is a decision they were not in a position to make.
Yes.
Yeah.
But if I could just, in very brief outline, say, I mean, I've identified, I think, about 8 points. So you'd have to necessarily ask yourself, was a notice to quit served? Point 1. 2, when did it expire? Because then that shows when he no longer had permission to be in the property. 3, was the notice to quit valid and validly served? 4, did Samwell accept the referral? When did they accept the referral? 5, why did the appellant not give up possession? Then 6, you've got the legal issue of whether that gives rise to a local connection. 7, there's a legal issue of residence, although I don't think the issue of residence is really tackled in either of those emails. And then lastly, you've got the legal issue of whether there's residence of choice, because they say it's not residence of choice, because it wasn't their choice that he stayed there.
But a lot of those are the same facts, aren't they? Because the notice to quit expired on the 2nd of September, I think. The council's review decision was on the 25th of September.
Yeah.
So things that had happened up to the 25th of September, the notice to quit, the unlawfulness of his occupation, all that were facts which the local authority had determined. So they can't be new facts.
No, I agree with that. They're not the new facts for the basis of the application. The new fact is, I've now been here 6 months. The relevance of those things is because they go to the quality of the residence and the issue of whether it gives rise to a local connection. So that's the fresh application law, and now I want to turn to the law on residence.
Which you say is irrelevant, because we're not at that stage.
I say local connection's irrelevant. I say residence is relevant because it's his residence which gives rise to his new fact.
Oh, I see.
So going back to the authority.
Well, all right, yes, I'm not going to stop you, but in fact, on your case, it is the assertion of the new fact
Yes.
that matters, and examination of the legal tests lying behind it is not appropriate at this stage.
Yes.
So, in a sense, what my lord put you is right, isn't it? That we don't really need this part of your submissions. I think we better have them in case. But logically, to your position, you have asserted, I have been here 6 months. That is a new fact. For all I know, it may not be good enough to assert, to justify local connection. But that isn't a matter, that was a matter which had to be considered by the statutory inquiry route, not by rejecting the application. Isn't that's the logical consequence of your...
Yeah, I mean, that's our primary case, but we don't just say we've been here 6 months, we say we've resided here for 6 months. It may be a triviality issue.
Well, I'm not, fine, we just wanted to see how this fitted into your submissions. I'm not going to stop you making them.
No, our primary case is it's a new fact, we've been there 6 months, whether or not it's residence, but our fallback position is, if it's said against me, well, it's trivial unless it's residence, because unless it's residence, what's the significance? So, starting in the Housing Act 96...
Well, that wasn't Mr. Penn's reason for rejecting your application.
Sorry, that wasn't his reason.
That wasn't his reason.
No.
He didn't say this isn't residence.
Yeah.
He said you don't have a local connection.
Yeah, yes. The reason I raise it is, as I've already explained, but I'm also... It may have been one of the reasons in the High Court judgment, which I'm obviously going to come to. So I feel I need to deal with it. Because I think it may have been said in the High Court, you did have a local connection, but anyway you didn't have residence. But it's not awfully clear. I don't my primary submission is the High Court didn't deal with residents either. So
I think we want to hear you on this, but I think there is a question mark as to how it fits in, which you accept. I think on the pure version of your case, it probably isn't relevant. But
Yes,
yeah,
I do.
okay.
So going back to the 96 Act, we've looked at section 198A1, which was on page 49, about the power to refer. The local connection provisions are in section 199 on page 55. So I'm on page 55. Subsection 1 says a person has a local connection with the district of a local housing authority if he has a connection with it. And then we're concerned in this appeal with A, because he is, or in the past was, normally resident there, and that residence is or was of his own choice. So we're looking for normal residence, and the only carve out from that is of choice. So it has to be of choice, but note the wording of his own choice. It's got nothing to do with the local authority's choice. So if the local authority don't want him there, well, that's irrelevant because that's their choice, not his. And also note the use of the word district. So it's not it's local connection with the district of a local authority. So primarily the focus is on why is he in the local authority area rather than why is he in a particular unit of accommodation. And then subsection 3 gives an exception. So district's not of own choice, effectively if you're in prison there.
Or a member of the armed forces.
Yes. Yeah, there are various carve-outs. Subsection 6, we say, is relevant because it goes to quality of residence. So my primary proposition at the start was that all residence is residence, whatever its quality. And subsection 6 deals with asylum seekers. Asylum seekers are persons who are not, if they have temporary admission.
So sorry, where, on what were you hooking your point about all residence is residence regardless of quality?
I was referring back to the first of our propositions this morning.
Yes, I'm sorry, but you were hooking it on one provision of the Act.
I hook it on various provisions of the Act and the Code.
So where in the Act are we?
Subsection 6,
Yes,
on
yes.
page 56. And this is a provision which gives asylum seekers a local connection with the district where they were provided with asylum support. And my short point on this is that if they are granted temporary admission as asylum seekers, they are not lawfully present in the country. See the case of ST, which I'm not going to take the court to, but the relevant bits on page 257 of the authorities, paragraph 57.
Well, if that's important, I really, I have to say, I don't not sure that it is. I think I'd need to understand that. In one sense, they might not be lawfully present in the country, but in another sense, they really are lawfully present. They've been temporarily admitted. It seems to me a point of immigration law, not really a point of any much relevance to the present case.
Are they eligible for assistance?
No. They're eligible for what was NAS. Precisely because of their immigration status, they're not eligible under Part 7 for homelessness support. But I agree with my lord, this idea of lawful, unlawful residence, in my submission, is primarily an issue of immigration law. And when one starts dabbling in what's unlawful residence, one strays into the area of immigration. And in my submission, the housing law is not supposed to be doing that in this context. But I'll come back to that. I'll make that good later. So that's section 199.
I'm ever so sorry. You said that subsection 6 supports your point on the quality of residence. How does it do that?
Because in our submission, an asylum seeker with temporary admission is not lawfully present in the country.
Is quality just a paraphrase for lawful or unlawful?
Yeah.
Yes, I see.
But it may encompass other things.
Right. Well, that's right. I mean, if I can just put my cards on the table, at the moment, I'm not terribly impressed by the. You've got to make your case because my lord and my lady may think differently. But I'm not terribly impressed by the judge's reasoning based on unlawfulness. But behind it, and this is rather one of the ways Mr. Grundy puts it, is a point more about precariousness. And of course, the fact that he was a trespasser may increase the precariousness of his position, and that goes to the question of normality. So at some point, I'd be interested in your submissions on that. I understand you've got to make your submissions. When I think about the quality, the reason I'm making this point now, to me, the phrase quality of your residence encompasses, as part of it, whether it is settled residence, and precarious is the opposite of settled. That seems to me to be what I think is the key question on quality of residence, if it arises at all. You may not agree, but you'll need to address that.
Before leaving the asylum seekers, there was one other point I wanted to make very briefly, which I think my learned friend objects to. But in a previous edition of the code, it's paragraph 7.9, and we've got copies for the court. The code expressly referred to unlawful residence in the context of eligibility for homelessness assistance. And the very short point we make is where the code wishes to refer to unlawful residence or lawful residence, it refers to it.
Well, hang on, if you're going to make this point at all, are you not going to give us... You can't just make it at that point as a throwaway. If it's not really important, don't make it.
No,
if it is important, we must show us the previous edition of the code.
I'm going to...
Did you want to copy, Mr. Grundy?
Sorry, we had an email exchange about this, and I have to say, what you've been handed up is a copy of the code that came into force on the 31st of December 2020. It came into force as a result of Freedom Day.
Okay. Well, perhaps I'm just puzzled that you weren't being given it when.
No, I have a copy.
You have a copy. Okay, that's fine. You can make your objection later then. Thank you.
My lord, it's the back page. It's the last page, and Mr. Grundy's correct. This was the code as it was in force from the 31st of December 2020 to the 4th of July 21.
So why is it relevant?
Because at that time the code included a reference to lawful residence.
Well, that time, yes, I see, but that's subsequent to the dates to which we're concerned.
Yes, no, I agree with that. So the short point is, where the code wishes to refer to lawful residence, it says lawful residence. And I don't take it any further than that.
Okay. You probably could have made that point. Without giving us the code, but as a general proposition. Okay, so the point is, could have said unlawfulness if it wanted to. Yeah. All right.
I mean, it harks back to the point made, I think it was in Enrique Begum, that if you want to start reading words into the statute, you're going to have a pretty difficult time of it, unless it's a very unusual circumstance.
Okay.
Well, that's true up to a point, but in a sense you are reading words into the statute because you're importing the 6-month guideline, which is not in the statute. It's in the agreement between local authorities. So,
well, I don't import that for the purposes of residence. My point is simply that the respondents, I think, they'll have to make his submissions, want to discount our residence on the basis that they say it's unlawful, whatever that means.
Well, that's certainly what the judge did.
I'll come to the judgment because I'm not awfully sure what the judge did. Then can I just look at chapter 10 of the code and deal with the normal residence point, and then make that good by reference to Mohammed. So I'm looking at page 82 of the authorities bundle, paragraph 10.5 of the code. So here the code's dealing with section 199(1)A, which is the normal residence requirement.
We've got. So I don't think we've actually got the provision, or if we have, but someone in the skeleton points out this is a code to which local authorities are obliged to have regard. So it is a statutory code in that sense.
182, I think.
Yeah, it's 182.
Oh, forgive me if it is in the bundle. I just hadn't spotted it.
Yeah.
Anyway, yep, fine. Sorry, you were taking us to 10.5.
Yeah, it's page 19, section 182, subsection 1. So in the exercise of their function, a local housing authority shall have regard to such guidance as may from time to time be given by Secretary of State. I was taking my law to 10.5. For the purposes of A above, normal residence is to be understood as meaning the place where at the relevant time the person in fact resides. So in my submission, what the code is saying is that normal residence is where you in fact reside, effectively equating normal residence with residence. And we'll say that.
Well, all right, that's what the code says, but it's not what the statute says.
Well, I'm going to take my law in a moment to Mohammed, where in my submission 10.5 comes from. Then there's a bit about temporary accommodation. Then there's 10.6, which in my submission refers to types of accommodation or types of occupation where the quality of residence may not be considered to be what the respondents term lawful. So, person who's street homeless or insecurely accommodated, sofa surfing. In that scenario, you need to carry out a different type of inquiry to be satisfied as their normal residence. And then it says, if an applicant has no settled accommodation elsewhere, and from inquiries the authority is satisfied they do in fact reside in the district, then there will be normal residence.
That seems to suggest the comparison between 10.5 and 10.6, that normal residence is taken to mean residence as is normal in a room or a property, as compared with a street or a sofa, rather than anything else.
Yes, I would agree with that. The conclusion is, in my submission, in both circumstances, it's still residence.
Yes, but that seems to be how it distinguishes
Yes.
normal residence and residence
Yes.
in unusual, well, not unusual for a lot of people, but what people would not regard normally as residence if you are sleeping in a shop window.
Yes. Yes, I agree with that analysis. And I think the other important thing about those examples is they may not be what the respondents term lawful residence, because you may not have permission to sleep in the shop doorway or in the park. So
Well, it simply doesn't address that question. I'm not concerned with that question. It's neutral on that point.
Well, I think
Sleeping on someone's sofa is not normally unlawful. Normally they've given you permission to do so.
Yeah.
And sleeping in a, I've no idea whether sleeping on the streets, it'd be a question of what the bylaws said, I suppose. It's not unlawful per se.
Well, my submission on those 2 points is you might have the permission of the person who occupies the property, but you might not have the permission of the landlord, and it may be that the tenant requires...
Well, you might not, but that's clearly not what this is addressing.
Well, in my submission, these are examples of residence which may be considered to be unlawful. So if you're sleeping in a doorway, you are probably trespassing on that doorway.
But one of the examples I think you gave to the judge was squatters.
Yes.
You might have been squatting in a house for 5 or 6 years, and then the paper owner turns up and says, "I want possession."
Yes.
That's been unlawful throughout. It's been a trespass throughout.
Now, I'm not saying you don't have good points about unlawfulness. I'm just not sure they're made particularly good by 10.6.
Yes. And then there is the local authority agreement at page 95, paragraph 4.3.
Sorry, are you coming back to 10.7? Is this as by way of preliminary to coming to 10.7?
No, I wasn't going to come back to it, so please.
Can you just explain to me, the implication of this is that residents of less than 6 months will not in a particular area will not normally be normal residents.
Yes.
What's the thinking behind that, or have I misunderstood what the implication is?
No, I think my lord's got that right. I think the implication is unless you've been there for a certain period of time, you're not deemed to have developed a local connection.
Yes, but you are in fact residing there. It's your home for the time being, for those 3 months. You are in fact residing there. Why should the fact you've only been residing there for 4 months or 5 months not make it your normal residence? It seems to be a slight mismatch between 10.7 and the way you're describing 10.5.
Well, my submission is that it does give you normal residence, but the way in which the local authorities have entered into their agreement is that generally it's not going to give rise to local connection. So it's a working
But local connection is satisfied by normal residence, isn't it?
Well, normal residence sufficient to establish a local connection should be residents for at least 6 months.
Yeah, but if you look at 19, have I got this wrong?
No.
Normal residence is a gateway, but it's not necessarily the answer, as Bet says. So what 10.5 is doing is explaining what normal residence is, and what 10.7 is doing is explaining what the local authorities regard as sufficient normal residence to establish a local connection. Because as we know from the House of Lords in Bet, the mere fact that you are normally resident somewhere does not inevitably lead to a local connection.
Yes, and that's set out at 10.13 going on to 10.14.
I had looked at Bet. I hadn't got that out of Bet, but if my lord did, he's almost certainly right. I had thought what Bet was saying was, in deciding what constitutes normal residence, i.e. the word normal, you've got to look at the statutory context, which is that it's part of a definition of local connection. Can we, I probably got that wrong, but I would just like to bottom this out. Can we just go quickly to what Bet does say?
Yeah, can we look at 10.13, 10.14 before we do that?
If that would help, yeah.
Yeah, that's what those paragraphs are doing. They're attempting to summarise Bet's.
Sorry. Yes, the more I look at it, I'm sure I'm wrong about Bet, but I would just like to have the nails.
Yeah, so Bet's is at 113, the authorities bundle.
It's page 126 in the authorities bundle, just above H, where Lord Brighton says the opinion has to be formed by notifying housing authority in a residence case is not whether the homeless person is now or was in the past normally resident, but whether he has now a local connection based on the fact that he now or was normally resident.
Well, I agree.
I think that I think what misled me was the language. The language of has a local connection because might be read as meaning that if you have this, then you have satisfied local connection. But as my lord says, the authoritative explanation is it doesn't mean that. It means the test is local connection, by which you must get at through one of those gateways, but they are not satisfying the gateway is not in itself sufficient.
Yes.
Thank you. Well, okay, we've got round that, and you've helpfully educated me. But to come back to 10.7 of the code,
the 10.7 of the code is saying once you're through the gateway, you're only going to get to your local connection with more than 6 months.
yeah, okay, thank you.
And that reflects page 95, paragraph 3 of the local authority agreement.
Yeah.
But does it reflect, 10.13 of the code says that the test regarding local connection as set out in section 199 subsection 1 should be applied. And if you look at that, a local connection has been established, a person has a local connection because he is, or in the past has been, normally resident there.
Yeah, there's no temporal requirement. I suppose.
No. So this 6-month guide, I mean, does it then become the new fact?
No, in my submission, no. But what it is what the local authorities will generally consider to give rise to a local connection. But it's not the new fact. The new fact is the resident, not the local connection. Local connection comes after.
Okay.
I want to look at 2 cases on this, Mohammed and N. So if I could start with Mohammed, which is on page 150 of the authorities, and I want to go, if I may, straight to paragraph 18 on page 156. Can I invite the court just to read paragraph 18, then I'll make brief submissions on it. So my submissions are between B and C, prima facie meaning of normal residence is a place where at the relevant time the person in fact resides. So normal residence is simply where you reside, and that's reflected in the code. The question, so long as that place where he eats and sleeps is voluntarily accepted by him, the reason why he is there rather than somewhere else does not prevent that place from being his normal residence. So the test for residence is where you eat and sleep and voluntarily accept. So that's the of choice. So it has to be your choice. And it's, in my submission, a very easy test to satisfy from the applicant's point of view. It's just where he eats and sleeps and where he wants to be. And it goes on to say that all manner of things, you can reside in all manner of different types of accommodation. And it can become your residence very quickly. And then at 19, the court makes the point that some types of residence are excluded. So as my lady noted, service in the armed forces, and then the other one's detention under statutory powers. They're not of choice, so they're excluded. And in that regard, it should be noted that residence of the sort that the appellant has in this case has not been excluded by the statute. And it is his choice. It may not be the respondent's choice, but the test is it his choice? And then at 20 is the issue of whether or not the interim accommodation can amount to normal residence, and it's said that it can. And then going over the page, 21 and 22, the court looks at bets and summarises the ratio in bets, which we looked at.
Yep.
And then the last case on residence is N, which is in the bundle at page 261, and I want to look, if I may, at page 303.
Can you give me the page reference again, please?
Yeah, so it starts at page 261,
Thank you.
and the relevant page for our purposes is page 303. It's paragraphs 44 and 45.
Sorry, which pages? Tell me again.
303. So it
Yep.
starts at 261. 303 is what we're looking at.
Thank you. Yeah.
So paragraph 44 deals with Mohammed, as we've just seen, and quotes with approval paragraph 18 about eating, sleeping, and interim accommodation can amount to normal residence. And then the conclusion that dwelling generally connotes a greater degree of settled accommodation than residence. And coming back to my Lord's point earlier, in my submission, residence has got nothing to do with whether it's settled.
Yeah.
That's dwelling. And then at paragraph 45, reside and dwell are ordinary words, don't have technical meanings. Words must be interpreted in the statutes in which they appear, having regard to the purpose of those enactments. And dwelling, as a general rule, suggests a more settled occupation than residence, to be equated with one's home, although residence can, in certain circumstances, acquire such an equation. And so you can reside in temporary accommodation, even though it's precarious. It's just given to you pursuant to homelessness duties.
Sorry, can I recast my question, having had now I've got a better understanding of Betts?
Yes.
Do you accept that precarity or lack of settledness can be relevant to local connection?
Yes, I don't rule it out, but I say it's irrelevant to residence.
Yeah, thank you.
If reside and dwell are ordinary words of the English language, which they are, why was it necessary to insert normal?
Yeah, that's a good question. I don't really know the answer to that, because the code then says, well, normal residence is where you reside, so it seems pointless.
Well, I've been thinking about this. Suppose a situation where someone lives 60% of the time. It won't be purely numerical, I understand, but just to make it numerical, 60% of the time somewhere, but has a place they quite often go to eat and sleep the remaining 40% of the time, or maybe travel a lot for work or for whatever reason. Isn't normal residence intended to say that the fact that they are sometimes away doesn't stop it being their residence? Make that clearer.
Yes.
That would be one reason for it.
Yeah, it's the two homes cases.
Yeah, well, that's really what I was putting. Yeah.
The last thing I want to refer to in this section is the statutory material that we've got at the start of the bundle. So just to make the point that residence is a well-known term in housing law. It appears outside the 96 Act, also in other acts. So page 5, if we put in the Rent Act, is particularly relevant in terms of succession, because one can succeed to Rent Act tenancies and to secure tenancies if you've been residing with the tenant who dies for a period of 12 months.
I think you made these points in your skeleton, don't you?
So I just made them in passing now.
Yes.
Well, you get it in all sorts of contexts, in tax contexts, in children contexts, in all sorts of contexts.
Yeah. But the significance is it's never been suggested in any of those contexts that one doesn't count residence that's unlawful.
Yeah. Okay.
That then takes me to the 2 grounds of appeal, finally.
This is your final head.
Yeah. I've made most of the submissions in the skeleton along the way, so I'm not going to repeat them. And they're in the skeleton, I've made them orally already. So I want to just focus on what I haven't said so far, and I want to turn then to the judgment. Judgment starts on page 36 of the bundle. I'm in the call bundle.
Yeah.
I want to start at page 37, paragraph 1 of the document.
Sorry, paragraph
Paragraph 1.
1.
Yep. So line 3, the judge says the short point in this matter can be stated as follows, namely whether the claimant acquired a local connection for the purposes of establishing that he was normally resident, having occupied temporary accommodation provided by the defendant and discharged an interim duty for more than 6 months, when the continued occupation was after the housing duty had expired, had been a referral, the referral had been accepted. So in my submission, he gets the issue wrong from the start. It's not whether he acquired a local connection for the purpose of establishing whether he's normally resident. That's going backwards. The question was, in fact, whether his residence gave rise to a new fact, or fundamentally whether there was a new fact. Because if there was a new fact, they had to take the application. And it didn't matter whether or not he had a local connection. That was something that they had to consider once they'd accepted the application.
Well, even in its own terms, the issue is wrongly stated, because assuming that the relevant question was local connection, it would be whether the council were entitled to find that he didn't have a local connection, not whether he had established that he had one.
Yes. But anyway, the whole argument's irrelevant.
Yeah, quite. You say so. This is a stage 2 argument.
Yes, exactly.
We're only at stage 1.
Yes. And that colours the whole judgment, because what the judge is really doing is hearing an appeal from a 184 decision that the appellant doesn't have a local connection. If I could turn to page 43, paragraph 29. Judge says in the first 2 lines, in submissions, counsel addressed me as to the nature of residence in this context. As an argument, it does not seem to be central to the issue I must decide.
Sorry, which paragraph are you on?
29.
Yeah, 29, first 2 lines.
Yeah.
So in my submission, this is a repeat of the error he made in paragraph 1. Residence is all in this case, because the new fact is based on residence. But he discounts the issue of residence because he thinks that the case is all about whether or not the appellant has a local connection. And in my submission, he doesn't actually really form a view on whether or not the appellant has been resident and has been resident in excess of 6 months. And indeed, looking at those 2 emails from respondents, they don't seem to either. But in my submission, that's the key issue. His decision is then at paragraph 44 and 45 on pages 47 and 48. So he sets out his findings at Roman 1 and Roman 2, so, or at least the background. So the only alleged new fact was that the claimant by then had resided in the temporary accommodation for more than 6 months. And he says, and thereby for that reason had a local connection, but we don't have to go that far, we don't have to go on to that, that's stage 2.
I'm ever so sorry, I've missed the paragraph that you're looking at.
44
44.
on page 47.
And the the subparagraph that you were referring to.
I'm starting at Roman 1, where he says
Thank you.
the only alleged new facts that the claimant had by then reside in the temporary accommodation more than 6 months.
Thank you.
And then he goes on saying, thereby for that reason had a local connection to Cambridge. But that, as I say, is really not relevant.
That's a really refinement on your argument, isn't it? I mean, it might be said that the only reason why having resident for 6 months is relevant is that it satisfies a local, it is said to satisfy a local connection. In this case, doesn't necessarily do so, but it is said to do so.
Yeah.
So I see why you make that point, but it doesn't, even if the judge was right about that, it doesn't really matter. Yeah.
But in fact, he is right. It's exactly what your client's solicitors said on page 157. They said he's been here for 6 months, he's got a local connection.
Yeah, no, I accept that. But insofar as they did that, they argued too much. They didn't
Well, that
need
may
to.
be, yes.
They didn't
But
need to, yeah. And the judge didn't need to consider the issue of local connection,
no,
and that's really what he
I
gets.
follow that. But as a summary of what the
Yes.
alleged new fact is, it's unexceptional.
Yeah. But he there, at least at Roman 1, does identify the importance of residence, but he doesn't, in my submission, really then form any conclusions on it. So Roman 2 sets out the facts about the notice to quit. And then Roman 3, other than the passing of time, nothing's changed. Well, that obviously ignores the whole residence point, because the whole argument is it's not just the passage of time, it's his residence in the borough for a period which is now in excess of 6 months. And then the judge says the claimant did not have a local connection with Cambridge. Indeed, his local connection was with Sandwell, who accepted the referral.
Again, you say that's a stage 2 question.
Yes, stage 2 question. The respondents and the judge are answering the stage 2 question. Local connection with Sandwell is irrelevant, because it doesn't mean because he's got a local connection with Sandwell that he doesn't have a local connection with Cambridge. Roman 4, in my judgment, in the circumstances of this case, the simple passing of time and the unlawful occupation of the accommodation cannot amount to a new fact. Now, in my submission, that's following his conclusion in 3. He's saying, like the respondents, because you don't have a local connection, you don't have a new fact, which is reasoning backwards. And he doesn't really deal with the issue of residence. In Roman 3, he's not really dealing with residence because he's ignoring the fact that the argument isn't just passing of time, it's residence. And in 4, he doesn't grapple with the issue of residence, and previously he's dismissed it rather as not being a particularly relevant issue. So what he had to ask himself was whether there was a new fact, whether the respondents were right to find that there was no new facts because he didn't have a local connection. But what's happening in Roman 4, and we'll see it in a moment in relation to 5, is there's an assessment by the judge, as there was an assessment by the respondents, of quality of residence and whether that gives rise to a local connection. And that's at stage 2, that's going beyond the fresh application test. Or was it identical to the previous application? And that, coupled with what we said in the skeleton, is really all I want to say in relation to ground 1. And so we're moving to ground 2, although this does, there's overlap between the two. If one then goes to Roman 5, what he's doing here in my submission is forming a view on the local connection decision. So the new application was also, in my judgment, wholly fanciful, i.e. unrealistic given the circumstances. So he's saying you made a bad fresh application. That was never, you were never going to show that you had a local connection. It was unrealistic. So he's saying that fanciful it isn't a credibility issue. It's a merits-based analysis of your future application. And as I've already argued, you don't reject a fresh application because you think it's a bad application. The actions of the claimant to frustrate CCC in not leaving the accommodation as he is required to, and preventing CCC from changing the locks and thereby preventing others from using the much-needed temporary accommodation, and failing to engage with Samwell is tantamount to a manipulation of the homeless statutory regime. Well, even if he's right about that, that is relevant to the local connection decision. And indeed that is, in my submission, what he's there dealing with. Those are all reasons why you may have required residence, you may have got more than 6 months residence, but it doesn't give you a local connection. See that. These are all stage 2 points. And of course, against that, he could have put into the balance all the things the appellant said about why his residence should count as residence. But he doesn't do that because if one rejects an application, one doesn't then inquire into the application properly. You don't hear what the appellant's got to say about it. It's a sort of one-sided game. And then at 6, he says, if such conduct were permissible, any person in similar circumstances without a local connection who is dissatisfied with a referral decision, as an example, would be able to frustrate the referral system by refusing to leave until such time as he'd resided 6 months in one area. No, that's not right, because, as Milady says, he could have reapplied, the application could have been taken, it could have been refused in a day, it could have been refused that afternoon, you don't have a local connection, and then applying section 199 capital A, that would have been the end of Cambridge's involvement, because Sandwell had accepted the referral, the duties lay with Sandwell. You wouldn't frustrate the system at all. That's exactly how the system works.
Is that right? Because you could have asked for a review, or he, the person in 6, could have asked for a review, and then could have appealed the review to the county court.
Yes, but it doesn't impact on the duties. We can go to 199A if my Lord wants to, but it doesn't get him a duty in Cambridge.
Well, it doesn't get him an interim.
Yeah.
Yes, I see.
It's all transferred off to Samwell. Samwell's then subject to the relief duty and subsequent duties.
Well, that's quite an important point. I think I ought to just, I'm sure it's right if you say so, but I think we would just make it good.
So it's section 199A, which is on page 58.
Page which?
58, my Lord.
Thank you.
So 199A is duties to the applicant whose case is considered for referral or referred under section 198A1. Sorry, I'll wait.
It's subsection 5, A and B, isn't it?
Exactly.
Yes, I see. No, it is. Mr. Van Heenen.
Sorry?
My Lord's got that right. It is
Yes, exactly.
5A and B. Yes.
Yeah, exactly.
So, just to spell it out, sorry if I'm being slow, but it's important. Asking for a review and appealing an adverse outcome of the review would not be operative to keep the duties in Cambridge. There would be duties, but they'd be owed in Sandwell.
Exactly.
So the way it would work, if he played by the rules, is he would then, Sandwell would then offer him something, and if he eventually won at the county court or they changed their mind on the review, at that point a duty would revive, would it? And Cambridge would have to accommodate him and Sandwell would cease to. Have I got that right?
Yes, I think that is right, yes. Yeah, if he succeeded in proving that, in showing that their decision that to refer was wrong, then yes, it would undo the referral. So that the just applicant doesn't miss out. But the unjust applicant, the one with the bad...
Well, he doesn't. The just applicant, he misses out in the sense that he has an interval during which he has to live in temporary accommodation in Sandwell rather than Cambridge.
Yeah.
But eventually he comes back to Cambridge.
Yes, if he's right, yes.
If he's right.
Yeah. Yeah. And if he's not right, then he should never have been in Cambridge in the first place, so he goes off to Sandwell and he stays in Sandwell, if that's
Yeah.
right.
So in this case, the fact that the referral had been made before the application to consider the new fact, the local authority would not have had to refer again after they determined the new fact. Is that right? Because it says duties to the applicant whose case is considered for referral or referred. So in this case, it already had been referred. So if they had gone about the correct procedure, as you would submit it was the correct procedure, they would have accepted the application, determined the merits of the case. If they were against the appellant having formed a local connection, they would then say, and we have already referred your case, which you have not appealed, and therefore our duties are completely ended as of 4 p.m. today.
I don't know the answer to whether they can rely on a previous referral. I don't think there's any case law on it. I don't think it much matters, because they could just say, well, we're referring now and they've already accepted, so we know they're going to accept.
Yeah, so you're on.
Since you are entitled, in theory at least, to make successive applications, one would expect a referral to be made on each application.
Yes. Yeah. But it's not a big deal, because you just email or send a letter through to Samuel, that's happened here, and then they say yes or no. But what going back to the judgment at 48, what these issues are all about, you know, the quality of his occupation, what he did to stay there, and so on, they're irrelevant to his residence, but they're relevant to whether or not his residence gives rise to a local connection. And what they illustrate, all these facts, if you like, they're all things which the respondents, information which the respondents have obtained by making inquiries in relation to the fresh application, and things which the judge has relied on. And that's not allowed in respect of a fresh application, rejection of a fresh application. If they'd taken it, then yes, they could rely on all laws to say no local connection. But they're not allowed to rely on this material to reject a fresh application. They're not allowed to make the inquiries.
And the consequence for the applicant of a rejection is that you don't have the protection of the review, you don't have the possibility of going to the county court, you are in effect forced into judicial review.
Exactly. So you end up having a judgment like this, which is effectively a merits-based decision on local connection, which should never be before the High Court, because it should be looked at on review and then go to the county court, and the county court should decide whether or not it's got it, whether the response.
And on review, which is the intermediate stage, you are entitled to make further representations, and they could be legal or factual.
Yes.
Which you couldn't do on a judicial review.
Yes, exactly. And that shows the unfairness of the way in which respondents behaved in this case, because they refused his fresh application, and at that point, that's the refusal, and he can't change that decision. Whereas, as my lord says, if there'd been a negative 184, then he requests a review, and then he's got the opportunity to put his case in the review. And they may have, taking account of other factors that he put forward, may have thought, well, actually, although initially we didn't like your case because we didn't like your quality of residence, now we've thought about it and we've taken into account all the factors that you put forward, well, maybe now you do have a local connection. I don't know. But, I mean, that's a question for the authority down the road. And the very last point before I sit down is just a very brief reference to paragraph 45, where the judge then effectively decides the case because he says that the rejection of the fresh homelessness application was not perverse. Well, in my submission, that was never the challenge. And the primary challenge was that your reason for rejecting the fresh application, i.e. that the appellant doesn't have a local connection, is simply a decision that wasn't open to you and showed that you had necessarily not identified the new fact and had not applied the new fact test. But you'd gone backwards by saying no local connection, therefore no new fact. And the judge sort of falls into the same error. But unless I can be of any further assistance, that's my submission.
No, thank you. It's been
I wonder if I could ask a
I'm
question.
so sorry.
Yes.
Can I just work through the example again, just to know that I understand the point? If the local authority had accepted the fresh application, the new fact
Yep.
application,
Yes.
they made their determination, however quickly that was, and they say, no, we're against you. We're not satisfied that this is a local connection at the stage 2, when they should have made the decision that you say the judge made before stage 1. What are the options open to the applicant then?
He
He
can
can-
request a review of that decision.
Yes, and the review then is conducted by someone different to Mr. Penn, someone senior to him,
Correct.
or should be. And once that review is conducted and concluded, the next step is county court.
Exactly. Let's look at the provisions for the sake of fullness. So if one looks at the authorities bundle, it's section 202 and then section 203 and 4. So starting at section 202, which is page 87.
Uh, 67.
67, yes.
Two oh two one C. D.
Yeah, it's not really that because it wasn't a 1.9 subsection 1 referral, it was a 1A referral.
Oh yes.
So it may be as to what duty is owed. It might be 1B.
Yeah.
Anyway, I don't think it's a point between us that he could request a review.
And so,
So we'll just pin down under which provision you would be in
I think
a no local connection decision case. Which would it be?
I think it would be D, whether the conditions are met for the referral of this case, because I think what the respondents are saying is you don't have a local connection with us, you've got a local connection with Sandwell. therefore we're
Yes,
going
I
to-
see.
but you can have local connections with more than one place.
Exactly.
So, but in any event, they would a request for a review of a decision could be made.
Yes.
And then, if that is against the applicant, it goes to the county court.
Exactly. So then one jumps to page 73.
Yeah, and there are obviously procedural requirements. Appeal must be brought within 21 days of being notified of the decision.
It's what's been described as akin to judicial review. So you have your quasi-judicial review in the county court on a point of law.
Only, on point of law only.
Correct.
Yeah. And in the meantime, the duties of the local authority to the applicant cease subject to priority need.
That is correct. We saw 199 capital A subsection 5 B, which is where you notify the conditions for referral are met. From that date, the notifying authority owes no duties to the applicant under this part.
Thank you.
There is a power to accommodate, isn't there, pending an appeal to the county court, although not pending appeal from the county court to this court, as I understand it. Local authorities don't often exercise it, but I think they do have a power to accommodate.
They do. It is 204A, which I think we don't have in the bundle. We don't have it in the bundle. So yeah, there's a power to accommodate on review and a power to accommodate pending appeal to the county court. And they can accommodate pending an appeal to this court as well. And my lord's right, they don't often accommodate pending appeal to this court, but it depends on the facts.
And is that decision to accommodate pending review reviewable?
Judicially reviewable.
Yes, but nothing.
But the accommodation pending the appeal to the county court is the subject of an appeal to the county court. And then the decision to accommodate pending an appeal to this court is the subject of judicial review. So it's a bit confusing as to
All
form.
right, thank you.
And just remind me, going back to 199A5, which we took quite quickly, if it, my lady was taking you through exactly what would have happened. If it's decided the conditions for referral are met, B, as we say, from the date of referral, or sorry, on the date of notice of referral, the notifying authority owes no duties to the applicants under this part. But the effect of A, which is treated as having made an application to the notified authority, that means the notified authority will come under the duty. That's how it works.
Exactly, because you can't get accommodation from an authority you haven't applied to, and you're treated as not.
No, exactly. But you're treated as having applied to Sandwell,
Exactly.
and Sandwell then come under if the other conditions for giving you interim accommodation are satisfied, they'll have to do it.
Exactly.
Yeah.
Those are my submissions.
Thank you very much. It's been very helpful. Yes, Mr. Grundy.
So, my lord, there was an interchange between you and my learned friend, between the panel and my learned friend, about, well, what would happen, and his position was that if the case was decided on the full application basis, which he says it should have been, it would just be decided in a day and referred off to Sandwell again on the local connection rule. Of course, that doesn't prevent Mr. Minott from making a further application the next day, and that being referred off to Sandwell. And there comes a point at which Mr. Minott ceases to have a local connection with Sandwell. And they say, no, we're not accepting the referral anymore because he now hasn't been normally resident here for a long period of time. So my learned friend's gloss over what would happen is, in my submission, not correct.
So in what respect is it not correct?
Because there comes a point at which Mr. Minott ceases to have a local connection with Sandwell. So that comes to my next point. In order for the local connection rules to apply, or the referral to be allowed, there has to be no local connection with the referring authority and a local connection with the authority referred to. So, my Lady Justice, Lady Macur, said, well, it's possible to have a local connection with more than one borough, and that's absolutely right. In those circumstances, if a homeless application is made to a local authority with whom an applicant has a local connection, that local authority cannot refer it. But they also cannot refer it if the applicant has no local connection with the applied to authority and no local connection with any other authority. And it is perfectly possible for people to have no local connection with any authority.
But wouldn't the local connection in that case have been created because of the past residence, which is appropriate to found local connection in certain circumstances?
So take the example of someone who moves from borough to borough, never staying any particular period of time in one borough for long enough to have been there to acquire a local connection. I was going to say 6 months, but that's wrong because the 6 months residence doesn't give rise to a local connection. It's, as my Lord Justice Lewison identified, it's the gateway through which you might be able to acquire a local connection. So that person isn't working, so they can't rely on the occupation requirements, they have no family connections with any particular borough, they don't acquire a local connection anywhere. And the
But
fact...
no. I'm sorry to intervene, but it's just that you said lost a local connection.
Oh, did I? Well, then,
You,
sorry.
you did.
I
And
apologise.
the point I was making is that the local connection is established by previous residents as well as present residents.
It is, but after a period of time of... So, under the local authorities agreement, you would have to... Or the way in which it's dealt with between authorities is that you would be 3 years residence over the last 5 years or the last 6 months.
I see.
So there is a guillotine, and I accept that it's not the statutory provisions, but there is a point at which a local authority can say, Mr. Minott, to use this example, hasn't resided in Sandwell for recently enough to have maintained his local connection. So that's sorry. So the use of the word lost is appropriate in those circumstances.
Yeah. Okay. Thank you.
There are two ways. There are two mechanisms in which a local connection referral can be made.
But hang on, suppose you're right about that. That's fine, and Sandwell might say that after a few weeks, after a few months, after a year or two. We don't know it. There will come a point where they'll say that, and they'll be entitled to say that. But in the meantime, there won't be a duty to interimly accommodate
Mr. Minott.
Mr. Minott.
There was no duty to house Mr. Minott from the day on which the referral was accepted.
Yes.
Yeah. But Mr. Minott remained in his accommodation and relies on that continuing occupation.
That's a
to found
different
his
problem.
local
That's
connection.
because he's
Well,
been recalcitrant.
With respect, it isn't a different problem because it indicates in practical reality what is the manipulation that is being attempted in this case and the glossing over what has happened. And I'm going to come to that. I'm going to explain to you why my learned friend has elided, unfortunately, the two powers on which a local connection referral can be made. And the problem has been complicated by the introduction of the Homelessness Reduction Act. So I'm going to take you to sections in the Act, in the 1996 Act Part 7, and where they came into force on the 3rd of April 2018.
Well, don't trail it. I think it's too complicated to just give it as this you'll say you'll be coming back to it, then come back to it. Or
No, I will, but the sections that came into force from the 3rd of April 2018 were introduced by the Homelessness Reduction Act. And the Homelessness Reduction Act allows a local connection referral to happen before a Section 184 decision has been made. So the
I
law...
can't follow on this unless we do it properly.
Okay,
Do you want to do it now?
I'll do it. Well, I'm happy to...
Well, it's entirely up to you. You must decide. But all I'm warning is if you're just trailing a point and say, I'll come back to it, unless it's a very easy point that I can pick up in trailing, it doesn't really help.
No. I think
It doesn't sound like a very easy point.
Well, in my submission, it's... I suppose I'm familiar with the Act, so for me...
I'm
it's
not
one
at all
that-
familiar.
No, I understand that, my lord. It is a point which I think will become apparent when I take you through the sections.
Okay, well, do it whichever way you want.
Right. So my learned friend took you to section 184, which is at page 20, behind divider 6 in the authorities bundle. Section 184 has been in the Act from its commencement, but was amended on the 3rd of April 2018 by the Homelessness Reduction Act. So section 184.1...
One second, I'm just going to make a note against that. Is that the Homelessness Reduction Act 2018? 17.
But not in force until the beginning of the financial year 2018.
Yeah, okay. No, it says, okay, thank you.
So for these purposes, for me to explain the first power of a local authority to refer a case, I'm going to ignore the new provisions that came into force under the Homelessness Reduction Act. So section 184.1 establishes the obligation to make inquiries as to what duty is owed, if any. to an applicant. And there are a hierarchy of duties. So where an applicant is homeless, has priority need, is eligible for assistance, and the authority do not find that they are intentionally homeless, that they've caused their own homelessness, the duty, what's referred to in housing law as the main housing duty under section 193 arises. So inquiries under section 184 would involve a consideration of whether or not the applicant is somebody to whom this main housing duty is owed. You'll see at subsection 2, section 184, subsection 2, my lords, my lady, that the authority may also make inquiries whether the applicant has a local connection with the district of another local housing authority in England, Wales or Scotland. If we move on to the referral duties at section 198, so that's on page 49, my lords, my lady, tab 6, page 49.
You described it as a duty. In fact, it's a power, isn't it?
The duty is a duty to make inquiries. I apologise, my lord. There's a power to refer.
Yes,
They don't have
you
to.
talked about the referral duty, but it's not a duty. It's a
No,
power.
it's a power. I apologise. Yes, absolutely. My lord, yes. So under section 198, subsection A1 was introduced by the Homelessness Reduction Act. So I'm not going to look at that for these purposes yet. Subsection 1. If the local housing authority would be subject to the duty under section 193, accommodation for those with priority need who are not homeless intentionally, but consider that the conditions are met for referral of the case to another local housing authority, they may notify the other authority of their opinion. So that the original power to refer on local connection grounds was only after all of the inquiries had been made under section 184 and the most advantageous decision in favour of the applicant had been made. And what you were doing was transferring the obligation to provide that applicant, what the local authority referring were doing was transferring the obligation to provide that applicant and their household with suitable accommodation. The Homelessness Reduction Act introduced section 189B, amongst others, which is on page 32 of your Lordship's bundle, Ladyship's bundle. What it did was the Homelessness Reduction Act intends to front load the obligation to house so that local housing authorities would perform effectively a duty to house people without having made the kind of inquiries that were necessary to make a section 184 decision. Section 189B, subsection 1. This section applies where the local housing authority are satisfied that an applicant is homeless and eligible for assistance. So no consideration there of whether or not they had a priority need or they were intentionally homeless. Unlike the main duty in section 193 and one of the matters that has to be considered under section 184. Subsection 2. Unless the authority refer the application to another local housing authority in England, see section 198A1, and we'll be going there next, my lord, my lady. The authority must take reasonable steps to help the applicant to secure that suitable accommodation becomes available for the applicant's occupation for at least 6 months or such longer period not exceeding 12 months as may be prescribed. Subsection 4, where the authority are satisfied that the applicant has a priority need and are not satisfied that the applicant became homeless intentionally, the duty under subsection 2 comes to an end at the end of the period of 56 days, beginning with the day the authority are first satisfied, as mentioned in subsection 1.
That's what, so that the main duty then kicks in.
So there's an obligate, yes, effectively. That would bring somebody, if they're you've decided under subsection 1 that they're eligible for assistance and that they're homeless, and under subsection 4 you've decided that they're satisfied that the applicant has a priority need, and you're not satisfied that they became homeless intentionally. So all of the criteria for section 193, the main housing duty, is satisfied, so that duty kicks in. So section 198A1. On page 49, my lords, my lady. If the local housing authority would be subject to the duty under section 189B, initial duty owed to all eligible persons who are homeless, but consider that the conditions are met for referral of the case to another local housing authority in England, they may notify that other authority of their opinion. So we have here a right of referral that takes place before or concomitant. It could coexist with at the same. It could be coexistential in time with the section 184 duty, but it doesn't require a section 184 duty to have been a section 184 decision to have been made. Under the old provisions, the original provisions, I apologise because they haven't been repealed, the right to refer only arose when a section 193 decision had been made under section 184. But following the Homelessness Reduction Act, a referral can be made without inquiries for the purpose of section 184 having been made.
Yeah, I see, that's very clear, thank you. I've now got it. You may want to develop this more, but sorry to see where we're going. How is all this, to what point is this relevant?
So my learned friend says, well, there was enough here to engage section 184. The change in fact was the continued occupation, and your local connection decision was one that was under section 184. But we can see because of the introduction of the Homelessness Reduction Act, local authorities can make local connection decisions without having had to engage section 184.
So does that mean that there is a special case to which the fire test does not apply?
My lord,
or do you accept that fire does apply?
I accept that for here does apply.
Yeah.
But the more interesting point in my submission, my lord, is does the ratio of Muhammad apply to accommodation that's provided in performance of the relief duty? I don't think I need to go there in order to defeat this appeal, so I won't. But in Muhammad, the accommodation was being provided in performance either of the interim housing to duty pending a decision, and thereafter a decision was made that the person was owed the section 193 duty, so it was made to perform the section 193 duty, and therefore it's much longer term than the kind of accommodation that is provided to perform the relief duty. But in Muhammad, all that was said was, or the extent of the ratio in Muhammad is interim accommodation may be normal residence.
You've teased us with that, but as you say, you don't need to go there. the important point, though, is what you answered my lord before, that you do accept that despite this statutory change, 5 years still applies.
Absolutely.
So in that case, how does this help you?
Because when we look at the application, the new application, it expressly says, I now have a local connection. So the question that was, the tennis ball that was thrown up to ask the question by the applicant, and we'll go to my learned friend's skeleton argument in the High Court because the judge dealt with precisely the issues he raises in his skeleton argument. So criticising the judge for that is grossly unfair. We will see that what is said in the application is, I now have a local connection. And that has to be seen in the context of the new provisions under the Homelessness Reduction Act. But
right, well, I suspect,
I'm
I'm not sure I've fully understood that yet, but no doubt I will after 2 o'clock.
my lord, yes. Thank you.
2 o'clock.
I'm sorry, my lord, before you go, I wonder if it'd be useful for us to cobble together a full copy of the core bundle for you. I'm sorry.
No, well, thanks to Ms. Lovegrove, I think it is, or was it Miss England, I have got...
You have everything.
Yeah, thank you.